this recording, I'm going to be looking at some special types of relationships that can arise in business and the various legal mechanisms that really govern these types of relationships. So the main area we're going to look at is the idea of agency, something we've looked at a little earlier in terms of contract law, where one person does something on behalf of another. But it's important to note also that agency is essentially a subset of a wider category of relationships known as fiduciary relationships. And so I'm going to talk, after explaining agency, I'm going to talk a little bit more about what it is to have a fiduciary relationship and the consequences and really the level of care that's required when a person engages or is forced into these sorts of relationships. And then I'm going to look at trusts. Now, like agency, trust is a type of fiduciary relationship, and the circumstances where a trust can arise has a bit of complexity around it too. Each of these areas is quite useful for people engaging in business practice, and it really is an important component of the law for you guys to know. So the first thing to know about agency is that it's simply one party having authority from another party to act in some way. And the nature of this relationship in most circumstances is to do with these two parties, what we call the principal, that's the person seeking to appoint the other party known as the agent to do a particular action or a series of actions, or to engage in a certain conduct on their behalf. And really the key component of this agency relationship is that the agent has the power to usually bind the principal in contract law. We would typically appoint agents intentionally and deliberately so that they go out and can contract on our behalf. In other words, stand in our shoes. But it's also important to note that in some circumstances where the agent does go and do engage in some form of wrongdoing, wrongful conduct, that they can also bind the principal in tort as well. So when we're thinking about this agency relationship, the key word, the key concept is this idea of authority. And there's three ways that this authority can arise so that a person is going to be valid as an agent. And the first of these two are to do with the agent and the principal and the relationship they have with each other. But interestingly, and quite importantly, the third type of authority that I'll talk about is actually to do with not so much what the agent and principal have negotiated, done, talked about, or in any way, shape or form done between themselves. It's actually about third parties looking at the agent and thinking that that person is going to have this requisite authority. So starting with the first type of authority, this is the most straightforward one. It's known as actual express authority. And this arises in the simpler sense where one party, the principal, asks another to act as an agent on their behalf. In many situations, this will be for reward, and so there'll be a contractual relationship as well, but that's not strictly necessary. The key part, though, is that the agent is overtly and expressly given authority to act in certain ways by the principal themselves. And this is contrasted with actual implied authority. That is where a person isn't given explicit instructions to do something, but they've been given some form of express authority that is extended in some way. And so the classic situation there is an employee. Employees act as agents of their employers. And in that situation, when, for example, a person working in say a hospitality environment, somebody working in a kitchen or waiting on tables, from time to time a supplier may come in and ask for a signature, usually to signify that particular goods have been received, supplies and such like. Now, Often in those circumstances, the employee, as I said, the kitchen hand or the person waiting tables, doesn't have overt, express, actual authority to do this thing, to sign the signature. Nonetheless, it's within the scope of what the two parties would have thought about at the time when they created this actual express authority. And we call that actual implied authority, where things haven't been overtly talked about, but through some aspect, either words or conduct, the two parties actually give the agent the power to do things beyond what they've expressly and overtly stated and talked about. Now, this third category of authority, this idea of ostensible or apparent authority, this arises in circumstances where the third party would believe that the party or the agent in the situation actually has the authority. Now, again, this is an objective test. It's whether a reasonable third party would think, based on all of the facts, that the principal actually was holding out the agent to have this authority, usually to bind them in contract. So to think of some examples here, partners, so people in a business partnership with each other, are essentially agents for the partnership, and they bind each other in contract. So if a person is working for example, a law firm that's established as a partnership, and on the letterhead of the that particular firm, or on the business cards, a particular person is stated as being a partner, even if they're not, even if they've, say, retired and they only carry on working for the firm and as a capacity as employee. In that situation, a reasonable third person would look at that and look at the conduct of the partnership as a whole and the way that this person is held out to be an agent. And from their perspective, it's quite reasonable that they would think that, again, this retired partner actually does act on behalf of the other partners, and this agent-principal relationship would apply. Now, because this is an objective test, we have to look at the underlying facts and really try and determine whether these things are reasonable or not. So, for example, if you go into a local KFC, if you're a vendor, say selling soft drinks, for example, and you come in to the KFC store and a person is there and they're wearing a KFC uniform, they've got a name badge on, all right, and they're standing in or near the front of that building, it's probably not unreasonable in those circumstances to assume that that person does work for this particular branch, even if they didn't work for this branch and they worked for another branch, and they just happened to be wearing the uniform and was just visiting their friends. In those situations, the courts look at, well, is it reasonable to think that this person would be an agent? And it's important also to note the conduct of that particular store. So, for example, if a person walks in wearing your KFC uniform, the store, if they recognize this and they acquiesce, don't do anything. If a supplier did come in and that was, again, a reasonable thing to do to get somebody to sign this off, then they would have ostensible authority to act in that place, and the courts would deem that particular store to actually be holding out this person. Now, however, again, it has to be reasonable. So, for example, if instead of the supplier of a small range of soft drinks came to that store, but instead the managers of the entire complex came in to get someone in the store to sign off on the lease for, say, a 5-year lease or something similar. Now, in that situation, clearly it is not reasonable to expect that a person just hanging around the foyer wearing a uniform is going to have or be vested with that amount of authority. And so when looking at this, these types of authority in these categories, it is important to note for this third one that there is this objective test. And so that if you're trying to analyze whether a particular person may or may not be held out as being an agent, just, in many situations, just use a bit of common sense. Okay, now, assuming that a person is an agent, so they do have this authority to act, we have to also categorize the scope of their agency. And really this falls within three sort of general areas. And the first of these are special agents. This is the most narrow, and this is where the principal grants authority for a person to act, usually for either only one or a small number of transactions. And a classic example of this is a real estate agent. Now, again, for those listeners that may have purchased real property at some stage in their lives, or intend to, that when you're going and you're looking for a property and you find one you like, you then contact the particular agent for the seller in that situation. And often these relationships are one-off. One person for residential property engages an agent who receives some form of commission from this. And once the house is sold, the agency comes to an end. Now, in some situations, it may be a series of things. Again, we stretched the real estate agent example out. If you had multiple properties, hey, please sell me all of my 6 houses in Townsville, for example. But this is contrasted with a more general principle of agency. When we think of general agents, we think of people like dealers, for example, that one party may appoint another as an agent to on-sell property, cars, for example. In that situation, it's not going to be necessarily for a discrete series of transactions. It can be an ongoing thing. So we use the term general agents to really describe people in those situations. And again, it's important to note that in these situations, the duration and the length of that agency, when we're trying to work out whether a person's acting within the scope, you have to take into account these particular categories when trying to work that out. And finally, we have universal agents. These are agents that are given very far-reaching and broad powers to act on behalf of the principal. And the classic case here is persons under an enduring power of attorney. Now, the powers of attorney rules are governed by statute. So in Queensland, the Powers of Attorney Act 1998, and it really maps out the arrangements that a person can have with another to act on their behalf in a wide variety of circumstances. Now, with this type of universal agency, you can set this up for it to kick in at certain times. And again, a common one is when a person lacks the capacity, physical or mental capacity to act. You can set up in advance a directive for another to act as your agent, to be able to deal fully with your property and also with healthcare issues on your behalf. Another situation is the board of directors. So in a situation where the board of directors for a company pass duly structured, correct and proper resolutions in a meeting, then they essentially have the power to go and bind the principal, being the company itself, based on those resolutions that are lawfully carried. And another example is partnerships, where partners are each an agent acting on behalf of all of the other partners of a particular partnership arrangement. And in that situation, they do each have this universal power to bind the others in transactions. Now, agency arrangements can arise in a few different ways. And the first of these, the most straightforward one, is by actually willfully and intentionally establishing a person to be your agent. And again, this is this consensual appointment, and it can be contractual, where you give some form of consideration to the agent for them to act on your behalf, or it can be voluntary, where a person is appointed to be your agent, and they will they're still bound by the same rules, but you're not bound to provide any consideration. Now, agency can also arise from estoppel. We've looked at estoppel a little earlier under contract law. There we were talking about promises, and that one party that holds out or makes some form of promise can be held to that promise even in the absence of a formal contract if they hold themselves out in that situation to be a promiser. The other side has accepted that, has relied upon it, and in situations that would be not in good conscience, have provided a benefit back to the person who wouldn't have had this, who wouldn't otherwise have had to provide consideration on that contract. Now, agency arises in a similar way here, in that in the absence of a situation where one party has expressly made another an agent, if they've acquiesced, they've basically let the person who's purporting to be an agent carry on, and others have relied on that agency. They've actively, the supposed principal is actively known about it, and they're going to gain some form of benefit as a result. Then they can't turn around at a later stage and say, oh, well, actually, sorry, that party wasn't formally an agent, and you ought not to have relied upon them. They're not my agent. In those situations, the courts will hold that the party that was being held out as being an agent actually is one, and the principal will be bound. Now, another situation where agency will arise is through ratification. Ratification is the process where a purported principal looks at what a person that may or may not be an agent has done, and basically puts the hand up and says, yeah, that's okay. What you did was okay. You acted within the scope of the agency that I broadly gave you. This is the process of ratification that happens after the event. Now, usually the principal will do this, first of all, to try and resolve any ambiguity in terms of whether an agent was actually acting on their behalf or not. But most commonly in situations where the agent has actually exceeded their expressed and sometimes even their implied power to act, but they've exceeded it and gained some form of benefit. So in that situation, the principal can say, I'll have that. You were acting as my agent at the time when you entered into this transaction. Therefore, the benefit that's gained is really going to belong to me. I'm ratifying that. And it has to be done within a reasonable length of time as well. Usually, as a rule, as quickly as you possibly can. Finally, we have agency arising through operation of law. This is actually a pretty narrow category. It doesn't happen very often. It's usually where an agent or a person that would normally not be in the situation of being an agent has to, through virtue of some necessary series of events, take charge. And so the classic example of this is the captains of ships in situations where they couldn't be contacted, from time to time, have had to take charge of goods, and often in situations where they're going to perish for whatever circumstances, and to on-sell them. There used to be some old rules as well to do with husbands and wives, and the wife being able to bind the husband in terms of providing necessities, but that's really an old area of law that's pretty much been defunct since the arising of Social Security law. So this agency through operation of law, pretty unlikely to come up in practice. You probably don't need to worry about it too much. Now, after an agency relationship is in existence, and again, the scope of the agency depends on the category, be it general, special, or otherwise, and in those situations, it's usually clearly defined when an agency relationship comes to an end. And so, for example, a special agent appointed to do one transaction. Once that transaction is finished, then the agency comes to an end through performance. An agency relationship can also end through agreement between the parties, or revocation on behalf of the principal. The principal can just say, hey, I don't want this to exist anymore. Now, it's also important to note that either side can bring it unilaterally to an end, is it either revocation by the principal or renunciation by the agent. but also the death of natural persons, or their mental incapacity, infirmity, bankruptcy, or in the case of companies, also a liquidation. If the scope of agency becomes impossible to fulfill, much like the doctrine of frustration and impossibility in contract law, that will also end an agency relationship. And if the scope of the agency relationship as defined and agreed between the parties, if that particular mode becomes unlawful at some point, that will also end the agency relationship as well. Okay, so if there is an agency relationship and the agent is doing something, we're just going to look now at the duties of the two. And the first thing to note that from the principal's perspective, in situations where there is an agreement to pay, then that's a pretty core component of it. The principal has to pay the agent. Now, in some circumstances, such again with real estate, that can occur at the time that the particular transaction occurs, and in that situation through some form of commission. Now, the other key part is that by default of common law, the principal has to indemnify the agent. So if they go and incur some form of expenses, that again in the process of undertaking what the express agency or things that are reasonably necessary in terms of completing the expressly agreed upon scope of agency, those expenses need to be reimbursed as well. And in those situations, again, if during the scope of the agency the agent commits some form of tort, then the principal is going to be held liable. Unlike the principal, the agent has a host of duties. And the first thing is do what the principal tells you to do in regards to the scope of your agency. You also have a general common law duty to exercise due care and skill. And you can't outsource, at least not without telling the principal. When you are appointed as an agent, as a natural person, you actually have an implied duty to act personally. In other words, do that thing yourself. Now, the next two, this idea of needing to account for property and for acting as a good fiduciary, are really core aspects of this underlying principle of agency. Now, the first one is that when you as the agent get stuff, physical property, that you account for that back to the principal. You don't just try and keep it all yourself. And this final one, though, is really core to the notion that when you're acting as an agent, you have to put the interests of the principal ahead of your own. Fiduciary duty is a very special, a very high level of duty that one person owes to another, and to do with where the interests of both parties sit. And so the key aspect to this is that while you're acting as an agent, you are a fiduciary as well as an agent for the principal. You can't make secret profits, for example, while acting as an agent on behalf of another. I'll talk about fiduciary duties in the broader sense shortly. Now, this concept of fiduciary duty is something that actually arises from equity and the remedies that you get, even though they're reinforced with common law and statutory rules. They're essentially equitable in nature. And the key component to a fiduciary relationship is that one person is undertaking to act and to subvert their own interests on behalf of another. You're doing something or suffering some form of detriment and not putting your own interests first because you're doing something on behalf of another party. And it's expressed in really broad terms. And that's why I really wanted to talk about fiduciary relationships independent of agency, even though the idea of agent and principal is a category of fiduciary relationship. There's a host of other categories as well, though. For example, trustee and beneficiary. The trustee, which is essentially the more powerful party in the situation, is forced to put her or his interests aside and to take care of property in that situation on behalf of the beneficiary. Similarly with solicitor and clients, where there is a situation where there is certainly a power imbalance, a solicitor can't take advantage of the client and make some form of profit or secret profit from in situations where they have a duty to advance the client's interest. Companies are an interesting one because companies themselves don't physically exist. Now, the company can either appoint agents, which follows the rules of agency, general law, but also companies have a board of directors, and directors owe a fiduciary duty back to the company itself. And again, it's that duty to maintain confidentiality, not breach trust, and to put the interests of the company ahead of your own. So you can't do things like make some form of secret profit from the company itself. Now, the next few fiduciary categories of fiduciary duty are interesting. Employee, employer. Now, oddly, when we think of this, usually we think of employers as being the more powerful party. But in terms of the nature of fiduciary duties, if we think about it, employees are the ones that are entrusted with the company's secrets. They are the ones entrusted when working as an employee to put the interests of their employer ahead of their own. When you are being paid a wage, you must, throughout the time that you are working as an employee, put your employer's interests ahead of your own. You can't just secretly run your own business on the side on your employer's time. With business partnerships, each of the partners, while also agents between each other, are also fiduciaries, status-based fiduciaries, and that they must take the interests of all of the other partners into account and not advance their own, again, to make secret profits or to breach confidence, to gain some form of profit at the expense of fellow partners in a business partnership. And finally, executor beneficiary, which is similar to trustee beneficiary, is the situation where a person who's entrusted with the property after a person is deceased, they're entrusted with the property to disperse it to beneficiaries. And again, part of this role, this very high, very onerous responsibility the executor has, is to not make secret profits from the position that they're in. Now, the key aspects to being a fiduciary is that you need to avoid having conflicts of interest. In other words, you, if you are a fiduciary, must put the interests of the other party, the principal in this situation, ahead of your own. And you can't make secret profits or take bribes. You also can't disperse secrets. You have to maintain confidentiality. Now, each of these things is a little tricky for the courts of common law to really find some form of remedy. And you'll recall from contract law, the default remedy for breaches of contract, for example, is just dollars. You get dollars in those situations. And the courts of Chancery, and again, this jurisdiction of equity, has always recognized that can be a little bit problematic, particularly where a person makes a secret profit and then gains a large benefit as a result. And in those situations, because this is under the court's equitable jurisdiction, the court has a lot more scope to actually take into account the underlying injustice that's occurred as a result. And so they have additional remedies to go and try and set things right, to maintain some form of justice where a person does go, accepts bribes, or makes some form of secret profits. And the key part here is an account of profits. If a person breaches trust, takes a whole bunch of money, but then makes a lot of money from that, or it earns a whole amount of interest, the first thing to note is that the court has the power to actually take those profits, to actually say, hey, when you were going and making all of this extra money, we're going to deem that you're actually still within the scope of your fiduciary relationship. Therefore, that money is going to belong to the weaker party in that particular relationship. And the courts have the power to reassign property and money from one party to another. Similarly, the court in its equitable jurisdiction can award injunctions to prevent parties from continuing to breach. And if people do ignore those, they're in contempt of court. They can actually be locked up for it. Finally, and I'll talk about this in a bit more detail, the courts have this power to award what we call constructive trusts as a remedy to try and resolve the underlying injustices that can occur through breach of fiduciary duties. Trusts and trust law is a really important aspect of our legal system. It is one that is not commonly understood, and it's one which is quite unique to the common law world. Something that didn't really arise in the continent, and many of the other legal systems around the world, there are some things which are a little bit similar. For example, the Waqif in Sharia and Islamic law, but by and large, this concept of having a trust relationship is really unique to our system, and so it's a really important aspect to really know, because it can actually impact business aspects of commercial relationships, as well as largely governing our private lives and the property that we have. And now the key thing to note about a trust is that a trust doesn't actually exist. At least it doesn't exist as a legal entity. A trust isn't a thing as far as the law is concerned. It can't sue or be sued. It has no standing in the eyes of the law. And this is a really important concept. It's one that's commonly misunderstood. A trust can be an accounting entity. In other words, we can calculate the assets that are held in a particular trust. And in fact, for tax purposes, we're obliged to do that. But trusts are a type of fiduciary relationship that involve property. And in particular, it's where there is a separation of the benefits and the burdens of owning property. And so it's key to note that in all trusts, there's this three-party legal relationship. The first person is the person setting up the trust. They're known as the settlor. They are the person giving their property away. Now, in most situations, the settlor is often a neutral third party who will voluntarily give a small amount away to set up a trust, often to do with things like bank accounts. It's often $10 and commonly done in situations where you get, say, your accountant, for example, to do that. They set up the trust by giving $10 to the trustee, which is the second party to this relationship, the trustee to hold for the benefit of the third party, which is the beneficiary. And so the key aspects to take from this is that once you establish a trust, the settlor has nothing to do with the trust after it is established. That's the first key step. And in fact, there are some other areas of law that make it very important that the settlor is independent and separate from this. They're the one giving their stuff away. And importantly, once they've given it away, they've got no mechanism of getting it back again. It's not something that you do lightly. Another key aspect is that once you've created the trust, you're actually separating what we call the legal title and the equitable ownership of that particular property. Now, the legal title is the person who legally and lawfully owns the thing. And so when dealing with the property, this party, known as the trustee, has to do all of the things that the legal owner would otherwise have to do in relation, for example, to managing the property. For example, here thinking in terms of real estate, the trustee has all of the burdens. They're the one that has to go and pay rates, for example. They're the one that has to maintain the property. In the case of shares, for example, they're the ones that have to manage the shares to see that the investments are maintaining a certain standard of returns, and they're the one that must go and actively reinvest money. They're the ones that have to spend time. And it's only bad stuff that a trustee does when undertaking, when doing this undertaking to be a trustee in a trust relationship. The beneficiaries, in contrast, have only benefits. They have no duties. Beneficiary receives only the benefits from the property, be it income, which can be throughout the life or duration of the trust, and capital, which can be either released in part or in whole. Now, trust, as you can imagine, is quite a complex area of law, and so it's important to note that trusts can be categorized in a host of different ways. And a couple of the key ones is to do with intention of the parties when creating the thing. The trusts are categorized in terms of the various rules that the trustees have in terms of distributing income and distributing capital. And also trusts are categorized in terms of whether they are done between living parties or whether they're done throughout the result of a person dying. So the first of these to do with intention, and I'll talk about this in a bit more depth a bit later. Trusts are usually created intentionally. So the settlor actually gives some money to another party, the trustee, and then the trustee actively and voluntarily takes upon themselves this undertaking to look after the property on behalf of the beneficiary. That's not always the case. And I just earlier mentioned constructive trusts. In those situations, it's certainly not the intention of one party. They wanted to receive some form of benefit, and it's the court, in fact, which says, no, you're actually deemed to be holding this property on trust for another person who's the beneficiary. Now, these rules to do with the distribution of income and capital, this occurs with these intentional trusts, and we separate those into those where the settlor makes it really clear about how income and capital is to be distributed. We call these fixed trusts, and often they say, look, you from the profits of a company all of the trust profit in any given year, it's to be distributed, for example, evenly amongst all the beneficiaries. Now, the beneficiaries, by the way, don't actually have to be named in a trust. So, for example, a person can set up a trust that says, all of the income is to be split evenly amongst all of my children, which at the time when the trust is created may have a certain number, but in any given year that may have increased or decreased, sadly. Also, you can name a category of persons. For example, all people who have attended a particular religious service continuously for the last 10 years, for example, provided that that group of persons can be identified, they actually can be beneficiaries, where the settlor has clearly expressed the class or category of persons that they intend to be the beneficiary of this particular trust. In many situations, though, and again this occurs a lot with family trusts, the trustees are given discretion. And in those situations, they can either give beneficiaries income for any particular year or not. They can choose to withhold it. There are certain tax rules which will apply depending on how that discretion is manifested. But at the end of the day, they can choose one way or the other. All the beneficiaries can do is ask them or compel them to administer the trust, to think about making a distribution and to make sure that they actually are following the rules, particularly in terms of tax and good governance. But the beneficiaries can't make the trustees actually give them a distribution in any given year. And finally, I just want to note that a certain class or category of trust is established by default when a person dies. When you die, all of your assets by default are actually placed into a trust, with a testamentary trust. Now, usually, if we're organized, we'll have wills which govern how and where we want these our property to be divided, and but that's not always the case. And in that situation, people have to go to the courts and ask a person to be appointed as what they call an executor. And then the executor has a fiduciary relationship to all of the potential beneficiaries of the will in that situation. And that process can be quite time-consuming. And if anybody is listening to this, as a golden rule, if you want to make life a lot easier for those that maybe the beneficiary of any of the property you currently have, go and create a will, particularly when you've reached the point where you actually genuinely have large amounts of property. It will save a lot of hassle and stress later. The last thing I want to talk about is constructive trusts. Now, we've talked about various aspects of law where equity intervenes to resolve some form of injustice. So some examples, for example, are undue influence and unconscionable dealings that we talk about in contract law. Now, in those situations where a party has gone and breached, in that situation, a quasi-contract, contractual obligation, in situations where it may be unconscionable or they may be exerting some form of undue influence, they can gain some form of benefit. Now, if the courts do find that that's happened, and this can also happen in other situations where there is a breach of fiduciary duties. For example, your agent makes some form of secret profits from the position they're in, or a company director makes some form of profits that or takes advantage of an opportunity that they've seen or realized that the company should have taken instead. Then the courts can say that, look, not just that we're going to account for the profits you might have made, we can also place what's called a constructive trust across property. And the advantage of doing that is, in particular across real property, land and buildings, is that real property often appreciates. And so that if a person, for example, exerts some form of undue influence in order to secure real property, and later on this person is presumably not under the undue influence of that person, so for example a religious advisor and follower, and they realize later on, oh hey, look, this wasn't a real contract, they asked the court to have it overturned for undue influence, and the court says yes. If in situations where the property has appreciated, the courts can ask for a trust to be held upon that particular property. Now, a situation where this has come up me personally in practice is to do with elderly people. It's not uncommon for elderly people to make deals with their children and say that, hey, look, I'll sell my mortgage-free house, give you the money, and you can buy a larger property with a granny flat. I'll live in the granny flat until I die, and at that stage, you're the legal owner of the house. So that'll that's fine. This arrangement's fine, and these arrangements go on for a length of time, a few years, and then there's a falling out between the elderly person and the kids kick them out, which they can do because they're the legal owners of the place. And so that it's not uncommon for the elderly persons to go to the court and say, I want my money back. It typically is often the kids don't have any money. They've got the land, and in those situations, the elderly person doesn't necessarily want them to sell their property in order to realize that or get that money back. So they just say, look, we will have a trust placed upon that particular piece of real property, and if that property goes up in value, the value of that trust will also increase. So it's an important thing to note that in common law, usually when you get damages, it's usually a fixed amount, but constructive trusts in equity can be a lot more flexible. And the other key part to note is that the person who is essentially awarded this constructive trust, again the elderly person in relation to their kids' property, they are considered to be a beneficiary, and the owner of the house, the kids in that situation, are deemed to be trustees. So they are at law considered by the court to be trustees and to have all of these duties of a trust imposed upon them. And if they do willfully, for example, waste the property, make sure it loses value, do so in sort of spiteful situations, they can be held in contempt as well. So it's just important to note that this idea of the constructive trust is a really key remedy. It's only available in equity, and to also note the other equitable maxims are going to apply. Don't take a long time before going to the court. Don't do other unconscionable things in relation to that particular transaction. You need to go to the courts, as they say, with clean hands, because equitable remedies are discretionary. They don't have to be given to you as of right by the court, and the courts will only do so if the situation is going to lead to some form of injustice. And so don't try and be trying to screw over the other side if you're trying to seek a constructive trust across property. So I hope this recording is useful in some ways. You guys have taken away some key aspects, knowledge about agency, fiduciary obligations in the broader sense, and also some trusts as well.